Happy New Year and welcome to our session today. Today is the 4th day of February in the year 2021, and we are delighted as the Wasilianahub community to be hosting our session with Mediation Service Centre leaders, where we have a review of the Kenya Court Annexed Mediation Rules 2020. This is the document that is referred to as a post-Naivasha Draft 1. During this discussion by mediation service centers or mediation center leaders, we are having an open review. And in this open review, we have an opportunity to give contributions, to critique, and also to construct on the document that is related to the Court Annexed Mediation Rules 2020. We will be looking at what's effective in it, what should be in it but is not in it, what possibly could be a value add contribution, and that is what we will be hearing from our mediation service centers who are mediation centers in Kenya. My name is Wangare Kabiru and I convene the Wasilianahub Mediators community, a great place to be if you're a mediator in Kenya. We are building a community of professional mediators in order to serve Kenya and across Africa. We will start our session today with the national words of the national anthem, wimbo wa taifa in Kiswahili. E Mungu nguvu yetu, ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. So welcome once again. As I've indicated that today we have mediation service centers and a leader from one of the mediation service centers in Kenya who will be giving us a review and their thoughts on the review that is ongoing to the Court Annexed Mediation Rules. Today we have Suluhu Mediation Centre represented by Edwin Apacha. Welcome, Edwin Apacha, for your personal introduction of the Suluhu Mediation Centre and your feedback to the Court Annexed Mediation Rules 2020. Karibu sana.
Asante sana, Wangare. Thank you for the introduction. My name is Edwin Apacha. I'm a certified professional mediator, conducting both court annexed mediation and private mediation. So apart from that, I'm also a mediation trainer. Okay, I train people to become mediators. And I'm glad that mediation being a new field in Kenya, we have a lot of people expressing interest to want to join this very noble field. Okay, thank you very much. I'm from Suluhu Mediation Centre. Suluhu Mediation Centre is a training institution. We conduct both physical trainings, that is workshops, and virtual trainings. And we also conduct physical mediations and virtual mediations. Thank you very much. All right. Now, basically, I'll go straight to the document and just I picked out specific items for discussion. I have 4 items, or in total I have 8 items for discussion. Now, I'll start with what I saw is good in the document. And I'm glad that something is coming up in regard to just trying to regulate the mediation profession. All right. Now, what is good in this document? Okay. Previously, when we've been getting information like, say, for instance, from court annexed mediation, or rather the mediation files, the value of the dispute previously was not on the document. And I'm glad that now, at least, there's that provision that the value of the dispute is addressed, or rather is included. This is good basically so that even as a mediator, you're able to have an overview, a general overview of what you're dealing with, all right? That is actually a very positive thing, okay? Then something else, previously we've had cases, or rather we've had files that do not have the contact details of the parties, which means we've had to actually rely on the lawyers to give us these details. And sometimes we've been having challenges which end up causing delays because you actually don't get to start the mediations in good time because probably there's been an up and down trying to find the contact details for the parties. But now if this is enshrined in the document and it is adopted, then you can even just directly communicate to the parties and just inform them of what is happening, that there's a mediation that is supposed to take place, as opposed to previously how it has been. And that is a plus. Very good for that. Now, there's also another aspect that I picked up in the document regarding the performance of mediators. And of course, usually, as they say, you cannot manage what you cannot measure. So this aspect of just assessing the performance of mediators is a good thing, because of course, there's always room for continuous development and continuous improvement. And of course, again, mediation being a serious field, you don't want it infiltrated by quacks. You just need to take it as a serious profession, just like any other profession. So yes, that thing to assess the performance of mediators is a very big plus, and we would encourage that to happen. Of course, just that we don't know the measures that would be used or the structure that would be used to do this assessment. But I'm sure that is something that is being worked on, so that we can actually just grow a serious profession in mediation, okay? And then something else I picked up is in regard to private mediations. Previously, yes, there was a mention that agreements reached through private mediation can be registered and enforced in court. But it wasn't really, it wasn't really very clear. But I'm glad that now we're having structures that will actually recognize private mediation and registration, and actually enforcement of this settlement agreement that will have been reached at. Okay. And of course, as you know, there are very many disputes out there that have not even gotten into the official court system, okay? And so if actually parties get to know that, yes, even an agreement reached through private mediation can be registered in court and enforced, of course, why not? They would actually be encouraged and know that, okay, we are getting into this sort of arrangement or this sort of settlement, and it's going to be recognized within the judicial system. That's a very big plus. And again, for mediators, this is a plus because you can be able to sell your mediation services to potential clients, okay, or potential disputants, because of course you encourage them, you tell them, yes, even if you reach a settlement, it is recognized or it can be registered and adopted by the courts, okay? So that I found that to be a very big plus, all right? Those are the key 4 items that I picked out as being positives, or rather things that are actually encouraging. However, in the same spirit, again, there are aspects I picked out that probably need to be worked on, okay? Of course, as a training center, we've had students asking, okay, now we've gone through the training, so what is going to happen next, okay? I would really have wished that there was a provision that we can have students or newly graduated students attend sessions, okay? Or other mediation sessions within the court annex system, so that they can have a practical feel of what, or rather how the sessions are conducted. Currently, that is not the situation. Actually, I think it's just for people who are on mentorship status who are allowed to do that, and of course with a letter from the registrar. Okay, so if you can adopt a manner or a way that actually encourages even just newly graduated students from training centers to attend these sessions, it can be a plus because this is a new field and it's growing, and maybe we should not form what you call maybe stumbling blocks to them trying to achieve the goal of being certified professional mediators. Maybe that is something that can be looked at. Now, the next thing is on mentorship done by training institutions. As a Suluhu Mediation Centre, we have a mentorship program. That is even after students have graduated, we still run with them, conduct role plays with them, so that they have a general feel of what a mediation session is. Okay, so if mentorship programs run by training institutions can be recognized in this document or could have been included in this document, I think that would have been a big plus. Okay. Now, something else to my next point. I see there's something, okay, it's about, okay, I know what I was talking about. This is about remuneration to mediators, okay? My thinking is, or my point of view is, maybe remuneration to mediators should be based on the value of the dispute, okay? Because for instance, Mediator Wangari, you've brought parties together and you've unlocked 2 billion shillings that was previously locked in a dispute. And then the payment is just standard just one that particular one figure. Maybe just to grow the profession or just to encourage mediators to even just work harder. Maybe should have been adopted that payment should be pegged on the value of the dispute where it applies, especially in commercial disputes, or other disputes that have a commercial value. All right. I think this would really be a great boost to the practice. And then still in the same spirit, maybe also remuneration can be pegged on seniority of the mediators, okay? Seniority in terms of experience. And maybe also looking at the complexity of the matters. You come across some matters that are really complex. You have to run for about maybe even 7, 8, 9, 10 sessions before you get the parties to reach a settlement. Maybe because of the input that the mediator will have put in to try and bring these parties together, maybe remuneration should also be looked at in terms of maybe that complexity, okay? Generally, that is my feeling regarding the document. Like I'd mentioned earlier on, I'd picked on 4 items that I thought should be addressed, okay? And I've talked about 4 items that I think are really very good for the document. And the same spirit, I've also spoken about 4 things that if they were incorporated in the document, then I think we'll be moving forward. Okay, Wangari, back to you.
Thank you very much, Mediator Edwin Apacha of Suluhu Mediation Centre. And we can say that we have got from you 8, which actually has been split in terms of what is good and what is areas that would need to be worked on. As indicated, today's discussion is with the Mediation Service Centre leaders or Mediation Centre leaders in Kenya, and it's part of the discussions with regard to the court annexed mediation rules, a review of the document that is known as or we are referring to as the post-Naivasha draft 1. And in today's discussion, and also in the discussions that we are having with the Mediation Service Centre leaders, we are having an opportunity for contributions, a critique, and also to construct, looking at what's effective, what should be in the document, and what's missing in the document, and also any value add contributions. And if I may recap what I have heard from Mediator Edwin Apacha, who is from Suluhu Mediation Centre. He's a mediator and also a mediation trainer and a court annex mediator. Is number 1, that what is good with the document is that the value of the dispute will be in the document. Secondly, is that files now are expected to have the contacts of the disputants, and so the mediator can actually be able to reach out to the disputants, and this may make the process much more efficient in being able to reach all the disputants and to communicate, to make arrangements for the sessions. Thirdly is also his recognition that performance of mediators is also highlighted, which mainly will enable the work that mediators do to actually be able to have, let me say, like measures, or sorry, not measures, a way that performance can be reviewed. Then from there also, the other good thing pointed out is regard to the recognition of private mediation. And specifically with regard to the recognition of private mediation is, or probably an emphasis on it, or clarity, providing clarity to it, which then would may incentivize persons who are disputants for private mediation with mediators, and so mediators may position their private practices for this. Mediator Edwin Apacha from Suluhu Mediation Centre has pointed out that areas that may need to be looked at is with regard to number 1, a need for an emphasis on how to support what you can call like new mediators or student mediators, or persons who have trained, how they can be able to access practical training in mediation. And I think this has been highlighted in different spheres with regard when you talk about young mediators, whether it's young mediators by age or they are young in their training. Secondly, also is with regard to mentorship and the need for recognition of mentorship mentorship programs, so that then institutions that are providing mediation mentorship programs can also be able to have an anchoring in an anchoring. Then thirdly, and tied also to number 4, is with regard to remuneration of mediators. The suggestion that this could be based on the value of the dispute, and specifically highlighting that with regard to commercial disputes, that this is an area that needs to be looked into. And then also, which I would take is the fourth one, is with regard to the consideration of seniority, complexity of the matter when it comes either to remuneration and the assignment of the matters. The gap that a gap which mediator Naivasha has pointed out is with regard to what is the measure that will be used to assess the performance of mediators. And I think with that, then that gives us a very, very good closing. We have been receiving the views from Suluhu Mediation Centre, and as one of the mediation serving center leaders in Kenya, and this is to the document that is currently in discussion, and the document is the Court Annexed Mediation Rules that 2020, and with that feedback, then we will be able to now close this discussion. So the document that is under discussion is the Civil Procedure Act, Cap 21, Court Annexed Mediation Rules 2020. That is the full title of the document, and it is the document that we are referring to as the post-Naivasha Draft 1. I wish to thank you, Mediator Naivasha, for your time, and also the team at Suluhu Media. Yes, welcome. And also the team at Suluhu Mediation Centre. We will be receiving views from other mediation center leaders as we are going on, which allows then our mediation service center leaders in Kenya to be able to give their feedback that may go to the judiciary, as the court annex mediation team and the mediation accreditation team is considering the next direction with regard to the court annex mediation rules. So I wish to thank you, and as traditional with our sessions, we will close this session with the words of our national anthem, which is the first stanza of the Kenyan national anthem. Mungu wetu ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. I wish you all a good day and a pleasant new year. Thank you and God bless you.